everyone, and welcome. We are so excited to be here today, and we're happy to have you with us for our special webinar, A Legal Roadmap to Surrogacy in 2026 with attorney Melissa Brisman. My name is Elizabeth, and I work for the CRM department at ACRC Global, and I work closely with our intended parents throughout their journey, and I'm thrilled to be hosting this session alongside today's expert speaker, Melissa. How are you doing today, Melissa?
I'm great. Thank you for having me.
Awesome. Yeah, I'm so glad that you're able to join us. This webinar is designed specifically for intended parents who are exploring or preparing for their surrogacy journey and want a clear understanding of the legal process. So whether you're just beginning to gather information or you're already working with an agency or clinic, our goal is to provide practical, up-to-date legal guidance to help you move forward with your journey in confidence. So our guest speaker, Melissa, will walk through key legal considerations in surrogacy. This will include contracts, parental rights, state-by-state differences, and some common legal pitfalls that can be avoided. We want this session to be informative, but also feel like a safe space. And so please feel free to ask questions at any time using the Q&A box at the bottom of the screen. And we'll have time at the end of our Q&A session to answer as many of your questions as possible. So a little bit about ACRC Surrogacy. We're founded in 2015 and headquartered in Irvine, California. ACRC Surrogacy is a global surrogacy agency dedicated to helping individuals and couples achieve their dream of parenthood through compassionate, transparent, and ethical family building journeys. In addition to surrogacy, ACRC offers gamete donation programs and IVF transportation services, providing seamless support throughout the entire process. With offices and trusted partners around the world, our team delivers personalized care, medical coordination, and legal guidance to ensure both intended parents and surrogates feel supported every step of the way. Our mission is to make growing families through assisted reproduction a positive, informed, and empowering experience for everyone involved. And before we dive into this discussion, I also want to let you know that if today's webinar sparks any additional questions or you feel ready to take the next steps, we'd love to connect with you one-on-one. We offer complimentary consultations where you can speak directly with our team to learn more about the surrogacy process and see if we are a right fit for your journey. You can scan the QR code on the screen to schedule a consultation, or you can also find it on our website at acrcglobal.com. And again, thank you everyone for being here. Let's get started. Now, I'd love to introduce our special guest speaker for today's webinar, Melissa Brisman. It's an honor to have you as our guest host. Would you like to do a quick introduction of yourself?
Sure. So my name is Melissa Brisman. I have a law firm that concentrates in reproductive law. We have licenses in multiple states and co-counsel around the United States. I actually helped draft the surrogacy legislation in 2010 in Taiwan. I've done thousands of surrogacies. I used to own an agency in 2019, so I know a bit about that. I had sold the agency that I had owned for 20 years. I work very closely with ACRC, and hopefully after this webinar, you'll know a lot more about the legal questions you need to ask. Just so you know, I'll be talking today about generalizations. So before applying any specific legal information, you should get personalized information specific to your case.
Right. And yeah, thank you so much for being here today. As a CRM, some of our most common questions do relate to the legal process from intended parents. So I think today's webinar will be very informative for intended parents, but also I'm excited to possibly learn some new information as well. All right, so now we're going to shift into the Q&A session. We'll dive into some of the most common questions that are asked from intended parents exploring fertility and surrogacy. Right. So for our first questions, we're going to talk about the legal basics and process, kind of 2026 update. So for question one, what are the essential legal steps intended parents should complete before beginning a surrogacy journey in 2026?
So before you start your journey, you obviously want to go see your medical professional and your agency, but you also want to be aware of the legal steps you need to take and the legal pitfalls, right? So you're going to need to, if you reside in the United States, you have less that you need to think about. But if you're outside the United States, in addition to everything I'm going to go over, you're going to want to talk to a local attorney about how you bring the baby back to your home country and make that baby a citizen of your home country. But there are three essential elements in the US that you need for a surrogacy. One is the contract and the principles of what goes into a contract. Like, do you want your carrier to terminate, which is a very big one, for birth defects, or are you more pro-life? The compensation, COVID vaccines, all of that, that's going to go into a contract. And we'll talk more about that a little later. Health insurance. How are you going to cover your carrier's pregnancy? That is part of the legal review. But the biggest thing is, how are you going to get both or one, if you're a single parent, your names on the birth certificate? So that's called a parentage order, sometimes called a pre-birth order, sometimes called a post-birth order. But you want to know what states will allow you to get the birth certificate to look like you want and that you need in the country that you reside. So I'll give an example. So if you have a baby, a surrogate that is going to deliver your baby in Pennsylvania, you can have a birth certificate that lists either a sole parent or both of you through a gestational surrogacy through a court order process. And you can even get a pre and post birth order if you need it for a foreign country. So this is a little bit complicated, right? But you want to know basically the three things that you need to know about are you need to have a contract with your carrier, you need to make sure that she has adequate health insurance, and you need to make sure you understand the process of getting your name or yours and your partner's name on the birth certificate and bringing that baby home. So those are the three major categories that you're going to need to know about.
Perfect. Awesome. And for question two, what are the key legal requirements for a valid surrogacy agreement?
So there's a lot that you want to go into the surrogacy agreement. So you need your carrier to have informed consent in the surrogacy agreement, right? Meaning that she voluntarily enters into this, no one's coercing her, she's not on drugs, she doesn't have a gun to her head, right? And then that's the biggest thing. And then the biggest thing obviously is for the intended parents, for the intent to be that the intended parent or parents are the sole legal parents, right? So each state is going to vary about what needs to be in that agreement, but in most states, you're going to need, if they're married, all parties within the marriage, right? So if you have intended parents who are married, they both need to be a party. If you have a surrogate who's married, they both need to be a party, right? Most states require that a person be over 21 to enter into a surrogacy agreement. There are some exceptions. There might be a requirement of a psych evaluation, a physical examination, sexually transmitted disease testing on all parties. But there will be other important things that are in your agreement as well. Whether or not the carrier agrees to terminate, whether she's going to let the intended parents in the delivery room, how much is her compensation, her lost wages, how is the parentage order going to look. The biggest thing to talk about is termination, and I like to go over that so everybody knows. So even if a state allows a termination, right? So you might be in a state that doesn't allow a termination, and then that carrier, if she needs one, would need to travel to a state where it is allowed in order to get one. There is no legal means to force somebody in the United States to have a termination. So if they say that they'll have it, that you could, and they don't, the legal remedies will be withhold money, sue for money, place the baby for adoption, take the baby yourself and sue for money. It won't be hold a gun to her head and force her to have the termination, because that isn't something that we can legally do. It is very, very rare for someone to refuse a termination when they agreed to it, but it is a small legal risk of the process, but it is something that everybody should know about when entering into the legal agreement.
Right. And considering termination, that is something like within our match meetings, for example, between surrogates and intended parents. That's one of the first questions that we ask to make sure before even starting the process that they are both on the same page. So for question,
Absolutely. That's usually intended parents' biggest fears, right?
yeah,
So we like to go over what can be done and make sure that you talk about it and that there's a good psych eval and match meeting to help with
right.
that.
Yeah. Awesome. So for question three, how does the legal process of establishing intended parents' parental rights work today? And has anything changed in recent years that intended parents should know about?
Absolutely. So I started doing this in 1998, so it's been quite a long time. I guess that tells you how old I am. And about I would say 24 years ago, I took a case to the Massachusetts Supreme Court that allowed you to get birth orders in that state. So it used to be that you had to adopt your child. Now, almost every state, not every state, you can get an order naming the genetic or intended parents on the birth certificate as legal parents. There are some states or some situations where you can't do it, but in most states, it's similar. What will happen is you get what is called a bunch of affidavits from the parties. So, an affidavit is a fancy way of saying a piece of paper that says this person is pregnant with this person's baby and this is how it happened, and it's notarized. You file all that with the court, and then the court declares the intended parents as the parents. Now that's going to vary by state law, but and like for instance, Tennessee doesn't allow that to happen right now if there's an egg donor involved. It has to be genetic parents. So we want to make sure we know the gametes and which states allow it, but it is allowed in most states and not that hard to get. Once you get the order, there's a process of what you do with it, but legal parentage is becoming easier and easier in the United States.
And is it hard throughout the years, like having to keep updated on all these changes for you personally?
Well, it is something that I have to do is keep updated on all the 50 states. So I'm a
Mhm.
member of an organization and we have colleagues in every single state. So have licenses in 6 states here, and we have colleagues and co-counsel in all the states that we can call before. So we make sure that we have the most up-to-date information. I wouldn't say that it's hard now because I've been doing it for 30 years, but certainly for anyone starting, it isn't something that you could just learn. And I always say, like, Dr. Google is not your friend. Just because Google tells you this is the way to do it, that does not mean that that's the way it's done in practice, or that that's really accurate. So I wouldn't rely on internet searches to get parentage.
Yeah, I think especially with ChatGPT, for example, we have a lot of intended parents now that use that as a tool. It can be useful, but it's the most useful to talk directly, to an attorney.
Yeah, and there are a lot of nuances, like different judges may require different pleadings. Some want a Zoom hearing, some want an in-person hearing, some want an affidavit from the egg bank. Each judge can be different, and if you don't have somebody who knows the system or knows who to speak to, you can create a lot of chaos.
Right. Right. Yeah. So for question 4, when reviewing a surrogacy agreement, what are the most critical clauses intended parents should fully understand before signing it?
So as we talked about, definitely termination. You want to make sure you're on the same page about that and you know the remedies and what would happen and if there's travel involved, what expenses. You do want to carefully go over the financial package because surrogacy is expensive, right? And it has gotten so as a key change, it has gotten a lot more expensive as it has become more popular, right? So something to make sure as intended parents that you're financially prepared and you understand like that the compensation is only one element. There could be lost wages, there could be other things involved in the contract. You want to be open about communication during the process and after the process, right? So, after the process, if it turns out that you didn't have a good experience, no one is legally going to make you talk to your carrier and no one is going to legally force you from not talking, but it's going to be a mutual agreement. But it's nice if you have no intention of speaking to the carrier after that you look for somebody who doesn't mind that because there's no reason to match with someone who doesn't have the same intention. So if you want to be in the delivery room and you want breast milk pumped, you just have to make all of those things clear.
Right. Right. So let's move on to contracts and legal representation. So for question number 5, how does a well-drafted surrogacy contract protect both the intended parents and the surrogate throughout the journey?
So it's a roadmap, right? So if you start any sort of process, you want to know what you agreed to. And they generally are 20 to 50 pages. I would say the average is about 25. There are some attorneys who wordsmith it and it's 55 pages, and there are some that don't put enough. If you see a surrogacy agreement that's 4 pages, you know that's not enough. Okay, that person isn't well versed in what needs to be done. But I view the contract, yes, you could fight about it in court, but I have had probably only one or two out of thousands ever go to court as for a dispute. Most you're going to work out amongst yourselves. So you view it as a roadmap for compensation, communication, um, for just what you're willing to do and not willing to do. A big thing during COVID was, will you take a COVID vaccine? Right? That's sort of died down now that we don't have COVID. But you want to just be upfront about what you're willing to do. Like if you're very against vaccines, please let your intended parents know that so that if they are very for vaccines, you don't have a dispute about that during the process. So I view it as a roadmap for the process.
Yeah, especially the vaccines, that is something as well that we ask both the intended parents and surrogates. So we even still, have intended parents that prefer a surrogate without any COVID vaccines. But we also have, the surrogates that have not had COVID vaccines. So yeah, that's another, say, important thing to figure out before going deeper into the legal process. All right, so for question 6, why is it critical for each party to have independent legal representation?
So when you have a lawyer, you have what's called attorney-client privilege, meaning that if you tell something to your lawyer that you don't want your lawyer to tell anybody else, that lawyer has to keep it confidential. And you want to make sure that everybody is free to voice their concerns. And our job as an attorney is to be the one to communicate that in a way in which your relationship is preserved, right, with either your carrier or vice versa. So you want everybody's voice to be heard. And the only way to do that is if the same person is not going back and forth between it. You want everyone to have their own independent advocate, right? And also, as the attorney, I want to be the bad guy, right? So if a surrogate doesn't want the parent in a room, but the parent really wants to be in the room, I'm going to be the one who explains it why to the other side if I'm representing the surrogate and sort of soften that blow so that there is no effect on their relationship.
Yeah, to keep a positive relationship between the carrier and intended parents, right?
Yeah, especially for finances, right? Money is always tough to talk about, right? So, as much as surrogates are very mature, good-hearted people, they are doing a job as well. And just like I don't work for free for people, surrogates shouldn't have to work for free. And it's very uncomfortable to constantly talk about money to the person. So money should stay out of the conversation with your parents, and parents shouldn't talk to the carrier about money. Like I always tell intended parents, if this is costing your whole life savings and or you're very rich, that's not relevant to the carrier. Like that should not be something, whether you're rich or poor, the money should stay between you and your counsel and your agency.
Yeah. All right. So for question 7, what does a surrogacy attorney, or what role does a surrogacy attorney play beyond contract drafting, and how long do you typically stay involved in a case?
Well, if the case goes very smoothly, I'm not that involved. I'm just doing the contract, checking in. I do check in every couple months with my clients, whether they're intended parents or surrogate, because I do like to see them, but at the end of the first trimester, start planning their parentage to get on the birth certificate and coordinating with the hospital to get a birth plan. So normally the agency helps a lot with that as well. We would get more involved if there was a legal question or an amendment. So I'll give a very simple example. In the United States, most of the time, only one embryo is put in the uterus. Sometimes a doctor will allow two. That is not frequent to put in more than one embryo. If a carrier only wants one embryo and she puts that in her contract, but we get to the second transfer and she agrees that she wants two embryos now and the parents agree and the doctor agrees, I may have to draft a simple amendment because the contract says only one embryo. So sometimes people change their minds about what they're willing to do after they become more educated, and then we have to make small amendments.
Right. And that's if both parties like agree to that, then you would.
Absolutely. Yeah, we can't make an amendment with only one party agreeing because, and the doctor would have to agree too, because sometimes the carrier and the parents want to put in two embryos, but if the doctor's policy is they only put in one, then you either
Right.
have to stick with the doctor policy or switch your doctor.
Right. Awesome. Yeah. So let's move on to state, federal, and international considerations. I know we do have some, international intended parents out there. So for question 8, how do surrogacy laws vary state by state in 2026? And how can choosing the wrong state impact timelines, costs, or parental rights?
Okay, so if you live out of the country, I like to go over how long you have to expect to be here, right? So if you live in a country and you want to go home quickly, some people, will stay here for 3 months, but let's say you only want to stay here for a month, right? Then you can't pick a carrier from, let's say, Virginia, which takes up to 8 weeks to get the birth certificate because you're going to be here for the 8 weeks maybe while we wait for the birth certificate. And then I would say a week to get the passport or if you need a visa. right? So you might be here for 3 months. So you want to know not only can you get a birth order to get your name, but how long does it take to get a birth certificate in that state so then you could apply for the passport to go home. So you want to, and then if you live internationally, you also want to consider, do I need a pre-birth order to get citizenship? Is a post-birth order okay? What needs to be in the order? And how do I get home? So those are all things that are going to be state dependent, gamete dependent, sometimes county dependent. So we're going to want to talk about that. In most cases, same-sex couples definitely need an attorney in their home state because they're going to show up with a baby and it's going to be clear that neither of them, if they're male, same-sex couple, carried the baby.
Right. Awesome. Well, thank you for that. And you kind of segued into our next question, which gets asked a lot. Can you explain the difference between a pre-birth order and a post-birth order and how intended parents know which applies to them?
Okay, so some states, a pre-birth order is an order that you are the parent or parents that you receive from a court prior to your gestational carrier delivering the baby. Okay, so that means at the hospital, if you don't have a pre-birth order, we're going to need power of attorneys or healthcare proxies or something to allow the parents to take care of the baby because a court has not adjudicated them as the parents. A post-birth order is an order that you get from the court stating that you're the parent or parents after delivery. So in most cases, not all, but in most cases, if you only get a post-birth order, the initial birth certificate will be printed with the carrier on it, and we have to amend it to place the intended parent or parent as the parents on it. A pre-birth order is preferable to most people, but some people who let out of the country need a post-birth order. So they either have to go to a state that only does post-birth orders, or we have to be in a state which will allow you to get two orders, which a lot of them will. But the basic premise is pre means before birth and post means after birth.
Right. And I know, yeah, some intended parents do get a bit worried about like the post-birth order and how that, sounds before versus before the baby is born. So I want to know if there's a way that you explain like how the post-birth order still, can ensure that the intended parents will still be the legal parents.
Sure. So if we get a pre and a post, because like for instance, Israeli clients want a pre and a post birth, then the
Mm,
pre-birth order is protecting them. But if you just get a post-birth order, some states just don't allow you to file. Like for instance, in New York, you get an order before saying you're the parent, or the state law in Florida says that you're the parent under the contract, but they won't let you file for the birth certificate or the order with vital records until after it's born. So it's really the law in the state that's governing, not the timing of the order. But sometimes the timing of the order affects the paperwork at the hospital. But in most cases, it's not something to really get upset about until you learn the facts and how the law works in that state, because a lot of times it's really just nuances with paperwork.
see. Awesome. Well, thank you for that. And for question 10, what legal considerations should international intended parents be especially aware of when pursuing surrogacy in the US?
Well, first of all, I think the biggest thing that they need to think about is cost, right? So what most international parents, not all, don't understand is that the US healthcare system is very different. And insurance isn't going to cover IVF, and insurance isn't going to cover their baby unless they get a special policy. And that healthcare isn't free here, which it could be in some states. So they need to understand that that cost is a risk and they need to budget for it, right? Because a lot of times they don't understand why someone's going to the doctor when they're pregnant and they get a bill. So I like to go over that they'll be responsible for a lot of it will be covered by insurance, but some won't. So they need to be understand what the consequences of that. Um, right now, I tell all, and this is a huge question right now. Right now, all babies born on US soil are US citizens. I cannot tell you what is going to happen tomorrow, but most likely there will be a path for that baby to be a citizen of the state from which the baby is from, that there will be a path to get the baby home. And right now, there is no legal concern that that baby is not a US citizen. Could that change in the future? It could always change in the future, but it's not something that any legal expert could tell you what's going to happen in the future, right?
Right. That's,
So
yeah, it's typical question that I get from intent parents as well. And especially me, I'm like, I cannot predict the future. So,
well, right now we have a president that has changed his mind on some things. So it, knowing what thing is important at the moment, given the political crises that we have going on, is impossible to predict. There will be some additional case law on U.S. citizens coming out probably in June of 2026, so we may have more information for you. But predicting that is like predicting who's going to win a basketball game, right? Unless it's there always things can change. But the biggest things to think about are how much it's going to cost you, how you're going to get home, and how you're going to make that baby a citizen of your home country.
Mhm. Right. And for question 11, it's very similar to what we just reviewed, but are there other recent political or legal changes that have affected reproductive law? And how should intended parents prepare for the uncertainties of the future?
So sometimes people come to the United States and think, I'm doing it in the United States. It doesn't matter what's happening at home, right? So let's just say there's no political unrest here. It's perfectly legal here. Well, Italy just made it a crime to come to the United States to do surrogacy. Now, there are still ways to do it, but anybody who lives in Italy needs to examine with a reproductive lawyer in Italy how bringing that baby home to Italy is going to impact them. Because as US attorneys, we can't tell them what's going on in their home country. So we have a network of lawyers in almost all foreign countries. So we can refer them to somebody to give them, but a lot of times they don't want to pay the money for that to have that consultation prior to getting a baby. And that's not prudent because then they won't know the risks, right? So we can't force anyone to do that, but it is a good idea to examine and speak to people who know in your home country.
Right. Yeah, that's really good advice. And moving on to expenses and risk management, uh, leaning towards 2026. For question 12, how can intended parents protect themselves legally if complications or unexpected outcomes occur during the pregnancy? I know you reviewed earlier that, having the contract is already very important. Is there anything you could add on to that?
Well, absolutely. So you should have caps on all expenses in the contract that you can. And the carrier should feel confident with those caps. Like, okay, you're going to have this much per week for childcare. And then if you're representing the carrier, say, can you do it for this much, right? So you have to have clear guidelines. But as far as protecting yourself from risk, there are a lot of insurance products you could get for certain things. Obviously, health insurance is going to protect against certain health expenses. You're going to have IVF complications insurance that you could buy. Life insurance, God forbid your carrier should die. Attached to that life insurance, you could have riders for yourself if you need to repeat the process. There's stillborn insurance if, God forbid, you pay out and you don't get a baby, which is very rare, but that's what insurance is for. So there's a lot of products for lost wages and and it's very important to examine what risk you're willing to take because insurance is just that. It's mitigating risk. So some people like to be overinsured. Some people have enough risk tolerance that they don't care about the insurance. So that is a big part of mitigating the risk. Obviously, the other risks that are not financial, like getting to keep your baby, is having a good lawyer explain the state law, making sure you have a good agency, a good doctor, that you review your references, that you do your due diligence.
Right. Yeah, transparency is definitely, I would say, the most important thing, especially like you mentioned, surrogacy is not something that's cheap. And so it's important that everyone understands the caps and like what insurances can be paid for. All right. So for question 13, what is your single most important piece of legal advice for intended parents beginning their surrogacy journey in 2026?
Don't wait to consult your lawyer until it's too late, right? So you want to talk, you don't need to have a full retainer with a lawyer before you have a carrier, right? But you should definitely have a consultation, and it's definitely worth having that legal advice told to you in both your home country, if you are outside the US, and with a US lawyer, because you're not going to know what to look for and you're not going to know what's important to you unless you have somebody explain it. So, for instance, I have this a lot. People pick a carrier in Oklahoma, get her completely screened, pay a lot of money, and then they find out that Oklahoma is the only state where you have to pay for the birth order before she's pregnant. So if she backs out, you've put down $3,000 to $5,000 on a carrier who may not get pregnant. You would want to know that before you paid for her screening. So asking the questions about legal before you get started is very important. And I know that people generally don't like their lawyers because the United States is a litigious society, but this is a collaborative arrangement. So keep in mind that this is a different kind of lawyer.
Right. Right. So that is all we have for the questions that we set up beforehand. Let me see if there's anyone in the Q&A. I don't see any. You can always, I'll go through a few more slides and you can always ask more questions. But I do have some questions of my own that I'd like to ask.
Sure.
We sometimes have intended parents that would like to keep their surrogacy journey very private, and they prefer like surrogates to do the same thing through like social media, for example. Is there something during the legal process that can be agreed upon? I know this is a specific question, but I was just curious.
Absolutely. We have in every contract social media guidelines that they all agree to. So it in the baseline says no using names of parties or any identifying information without permission of the other. No ultrasound photos, no location, but some people want to share their journey and then they'll edit that in the contract if all the parties agree.
See. Okay. And then I guess more of a fun question from your experience, what is the most unique request an intended parent or surrogate has asked during the legal process to be put in an agreement?
So one person wanted the placenta, the surrogate, because she wanted to eat it. So I thought that was
Oh my
very
gosh.
unusual. Um, I had never heard that before. Clients can give me very unusual requests. Like one recently didn't like the cookware. So they bought all new cookware for the carrier, who was thrilled, by the way, but they didn't
Yeah.
want her using any plastic. So she got like
Mm,
all new containers and no Teflon on the pots. Sometimes people can get carried away. I did have a carrier get a home chef because they wanted to make sure she was eating well. So if I could
wow.
have carried my own baby, I would have wanted that home chef too. So
I know a lot. I've heard like some initial consultations, like especially with diet, for example. And will typically say like if the surrogate agrees to it and you're willing to pay for it, or the intended parents agree to it, and then they're willing to pay, then that's something you can put in the contract.
yeah, I mean, it's hard to enforce dietary restrictions, and a
Mhm.
lot of times, but if you have certain restrictions that benefit both, like who's
Mhm.
going to say no to new pots, right? Like
Right.
that's
Or a
not
private
something that,
chef.
yeah, no one's going to say no to that.
Awesome. All right, so I'll go ahead and move on to our final slides here. But thank you again, everyone who has joined us today, and a special thanks to Melissa for being such a wonderful guest and a resource. We hope today's webinar gave you guys helpful insights, answered some of your questions, and most importantly, reminded you that you're not alone in this journey. Our team and Melissa's team is always available to help you and support you every step of the way. And if you do want to connect with us directly, ask a follow-up question, or schedule a consultation, our contact information is up on the screen now. And Melissa, do you have any contact information that you'd like to share? Or what's the easiest way to
Um,
reach out to you?
sure, you can get us at going to reproductivelawyer.com, or you could just do melissabrisman.com. That will take you to the same place, or you can reach us at 201-505-0099.
Perfect. Awesome. Well, on behalf of all of us here, thank you again. And we wish everyone the very best path on your journey to parenthood. So take care and goodbye for now, everyone.
Goodbye. Thank you for having me.
Bye. Thank you for coming. Have a good day.